The police can take every dollar in your wallet without arresting you, without charging you, and without ever proving you committed a crime. In February 2021, Stephen Lara learned this the hard way. He was driving through Nevada with $86,900 in cash, his life savings, withdrawn to buy a home near his daughter's. State troopers pulled him over for allegedly following a truck too closely. They found no drugs, no weapons, no criminal record. They issued no citation. Then they called a DEA task force officer. A drug detection dog sniffed the cash, and the officers seized every dollar. Authorities filed no charges. Lara was not arrested. The government simply took the money. 7 months of litigation followed. The federal government eventually returned his full $86,900 without conceding any statutory liability. No apology, no admission of wrongdoing. And under current federal law, this was completely legal. This is civil asset forfeiture. And the central question is simple. If nobody is charged with a crime, why does the government get to keep the money? The answer involves a legal fiction where your cash becomes the defendant, a financial incentive that pays police departments directly, and a system that makes fighting back more expensive than giving up. Lara's case is not unusual. Between 80 and 89% of all civil forfeiture proceedings end in default judgments or administrative forfeitures. The property owner never fights back, not because they were guilty, because fighting costs more than the seized amount. The median state civil forfeiture value ranges between $500 and $1,500. Retaining a private attorney to navigate federal administrative procedures typically requires an upfront retainer of $3,000 to $10,000. A passenger dispossessed of $2,500 in cash faces a straightforward calculation. Spending $5,000 in attorney fees to recover $2,500 yields a net loss. Civil asset forfeiture actions are civil proceedings, so claimants have no constitutional right to a court-appointed public defender. The system doesn't necessarily have to prove you're guilty. It only has to make fighting back too expensive. The legal mechanism that makes this possible is called in rem jurisdiction. In a criminal case, the government prosecutes a person. In civil asset forfeiture, the government sues the property itself. The cash becomes the defendant. Court dockets display bizarre case captions, like United States versus $4,300. This legal fiction comes from English common law and 18th century maritime admiralty enforcement, when governments seized ships used for piracy. The Supreme Court adopted it for domestic use in 1827. Modern law enforcement has adapted this centuries-old maritime doctrine to highway traffic stops and airport screenings. But the real question isn't how they can do it, it's why they do it. And the answer is money. Under the Department of Justice's Equitable Sharing Program, established in 1984, state and local police can transfer seized cash to federal agencies for federal adoption. The federal agency processes the forfeiture and returns up to 80% of the net proceeds directly to the local police department's restricted fund. So the department that seized the money can ultimately benefit from the money. Between fiscal years 2000 and 2019, the DOJ dispersed at least $8.8 billion through this program. And suddenly, forfeiture isn't just law enforcement, it's revenue. When a local officer seizes cash during a traffic stop, the agency can bypass restrictive state court procedures by transferring the asset to the DEA or ATF. The federal agency processes the forfeiture and returns the majority of the proceeds back to the local department, outside the standard local legislative appropriation process. The more cash they seize, the bigger their budget becomes. The incentive is built into the system itself. Fiscal federalism at its most efficient. So what happens when a state tries to stop this? Since the 2000s, numerous state legislatures have enacted reforms. New Mexico, North Carolina, and Nebraska abolished traditional civil forfeiture under state law, requiring a criminal conviction before assets can be permanently forfeited. California passed Senate Bill 443, which mandates a criminal conviction before state law enforcement can receive shared federal forfeiture proceeds for cash seizures under $25,000. But California still allows forfeiture without a criminal conviction for cash over $25,000. Despite these state-level restrictions, law enforcement agencies frequently utilize the federal equitable sharing program to route cash seizures around state conviction mandates, processing the forfeitures under the lower federal standard unless explicitly barred by state statute. Lara was not alone. Terry Rowland, a 79-year-old retired railroad worker, consolidated his life savings of $82,373 in cash. His daughter carried the currency through Pittsburgh International Airport to deposit it into a joint bank account for her father's medical care. TSA screeners flagged the cash. Federal agents seized the entire amount without arresting or charging the passenger with any crime. Following public scrutiny and public interest litigation, the government agreed to return the money before trial. His daughter was not a drug dealer. She was not a money launderer. She was simply carrying cash through an airport. Another case shows what happens when the seizure targets a business opportunity. A Chinese-American restaurateur was driving through South Carolina with $75,000 in cash collected from family members to purchase a new restaurant location. Local officers pulled the vehicle over for a minor traffic infraction, discovered the currency during a consent search, and seized the entire sum under suspected narcotics connections, despite finding no illegal contraband. The driver was released without charges. 10 months of administrative filings and court proceedings followed before the owner secured the return of the capital. By then, the commercial real estate purchase agreement had expired, and the business transaction collapsed entirely. The legal standard reveals why this framework is so difficult to challenge. In a criminal trial, the government must prove guilt beyond a reasonable doubt. In civil forfeiture, the government only needs to establish its case by a preponderance of the evidence. That means slightly more likely than not, a greater than 50% probability. The same cash that would require near certainty to convict a person can be confiscated based on a coin flip standard. Under 18 U.S.C. Section 983D, an innocent owner defense exists for individuals whose property officers seized due to the criminal acts of others. But the claimant bears the affirmative burden of proving, by a preponderance of the evidence, that they either did not know of the conduct giving rise to the forfeiture, or upon learning of it, did everything reasonably possible to terminate the illegal use of the property. On May 9, 2024, the Supreme Court decided Cully versus Marshall. The question was whether property owners were entitled to an immediate hearing after officers seized their property. The court said no separate preliminary hearing was constitutionally required, which means your property can still remain in government hands while you wait for the actual forfeiture process. Federal lawmakers have responded with reform legislation. The Fifth Amendment Integrity Restoration Act of 2025, introduced in the 119th Congress, asks a simple question: how do you remove the incentive? It would eliminate administrative forfeitures, requiring all federal forfeitures to proceed through formal judicial proceedings. It would raise the government's evidentiary burden from preponderance of the evidence to clear and convincing evidence. It would direct all forfeited funds to the general fund of the U.S. Treasury, rather than agency-controlled forfeiture funds, severing the direct financial linkage between policing and revenue generation. It would prohibit federal adoption of state and local seizures, closing the equitable sharing loophole. And it would authorize federal courts to appoint legal counsel for indigent claimants. The bill remains pending. If you are traveling with cash in the United States, here is what the law says about your rights. You have the right to refuse consent to a search of your luggage or vehicle compartments. Officers cannot lawfully conduct a search without a warrant, probable cause, or voluntary consent. You are not legally obligated to answer questions about the amount of currency you carry, your travel history, or your financial background. You may assert your Fifth Amendment right to remain silent. If police seize your cash, demand an official, itemized property receipt detailing the exact amount and the seizing officer's information. Never sign any document declaring that you abandon or disclaim ownership of the funds. Such waivers legally surrender your due process rights and prevent subsequent legal challenges. If you receive a notice of forfeiture, remember the deadlines. You have 35 days from receipt to file a sworn administrative claim. If you file a claim and the government does not file a judicial complaint within 90 days, they must return your property. And if you substantially prevail in court, federal law requires the government to pay your reasonable attorney fees, litigation costs, and post-judgment interest under 28 U.S.C. Section 2465B. The strangest part isn't that the government can take your money. It's that in some cases, the money can be treated as the criminal, while you are left fighting to prove it's yours. Civil asset forfeiture remains one of the most asymmetric enforcement frameworks in American law. A legal fiction born in maritime piracy cases now governs highway traffic stops and airport screenings. The combination of low initial standards of proof, statutory revenue-sharing mechanisms, and prohibitive litigation costs means most seizures go unchallenged. Recent Supreme Court precedent has reinforced existing administrative timelines rather than expanding procedural protections. Whether the FAIR Act or similar legislation eventually passes will determine whether this centuries-old doctrine continues to shape modern policing. Next week, why a fast food chain tried to stop hourly sandwich workers from leaving, and how the federal government eventually stepped in. You will want to see that one.